Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. It's Thursday night. Let's go ahead and get started. Welcome to Thursday night. The week is flying by once again. Every time we do these things on Thursday night, I think, man, we're already almost there. It's already almost Friday tomorrow. So, hey, everybody, appreciate everybody checking in like we do each and every Thursday night, where we talk about debt and all things, related to that, all bankruptcy, debt collection, lawsuits, go over some tips, some strategies on how to deal with those things. And that's why I started the Consumer Warrior YouTube channel all those years ago. And I think I have over 600 videos on the channel now that deal with these types of issues, just to provide you some information and maybe some place to kind of be able to find some, tips and strategies to dealing with the really difficult things, the really hard things. Because that's what I found. You'll find some things on budgeting. You'll find some things on ways to be financially sound, which is good, but that doesn't always help you if you're really in a crisis situation. And that's what I wanted to help you with, is to give you some strategies on how to deal with that. Now, I am a licensed attorney in the state of Arizona. I practice law here. I do bankruptcy. I defend people against debt collectors. I do litigation. So I've had a lot of experience, nearly 20 years of doing this. I'm only licensed in Arizona, so I can't give legal advice to people who are not in Arizona. I don't know the laws there. I don't know all the statutes. But I can point you to some different resources, and this shouldn't be considered legal advice. If you do need information, specifically legal advice in your state, I recommend you contact an attorney in your specific state who can help you out with that. A couple things. How we do this each and every week is, if you do have questions, you can go ahead and put them in the chat section on YouTube, or leave a comment in Facebook, and that will put it up on the screen, and then we can go over and discuss it, and I can tell you kind of my thoughts on it. Again, if you're in the state of Arizona and you want to set up a consultation, my number and the website, everything's scrolling along the bottom of the screen there. Feel free to reach out. It is only Arizona. Unfortunately, I get a lot of people who set up or try to set up consultations, and because of the whole licensing thing, I'm not able to do that. So let's jump into a few of the questions here. Like I try to do each and every week, because I try to grab a few off of the comments from the channel. Let's try this one right here. It says, I got a letter yesterday from the court. Capital One Bank is trying to sue me, but I called the creditor today and got it settled. Do I still have to file an answer to the summons? This is a good question, and a question I get a lot. As far as if you actually have to respond, if you get it settled pretty quickly. And I think that's not a bad strategy, because, if they sue you, you get served, you reach out to them. That's why they're doing it. They want to spur some type of action by you. Yeah, sometimes you can get a good deal before they put a ton of effort into the case, and you can get the whole thing taken care of immediately. So, but the question is, if they do that, do you have to file an answer? Now, if you don't file an answer, you can end up with a default judgment against you. If it's been settled and you've paid it, and if it's in writing, that's one thing I always talk about. You need to get something in writing that shows that it's taken care of. As part of the settlement process, you want to talk to the other attorney and make sure that they're going to dismiss the case, and that they're going to dismiss it with prejudice. That means that it cannot be refiled again, that it's done. It's just completely over. And so you want to make sure you get something in writing that they're going to do that. And they can do that without your permission. Something that's interesting in civil cases under the rules of civil procedure in most states is if they file a lawsuit and you haven't responded to it, they can just dismiss that lawsuit. However, if you do file an answer, they typically cannot dismiss the lawsuit unless you agree to it, unless you sign off on it. So all of that is to say, if you have a settlement in place, it's in the settlement agreement, it's in writing, you need to get them to put in writing what they're going to do, that they're going to dismiss the lawsuit, that they're going to dismiss it with prejudice, and get the whole thing to go away completely. So that's something to be careful of there. This person was asking about a Chapter 13. How do I get a loan in a Chapter 13 for a car? So Chapter 13 bankruptcy is different than what most people file Chapter 7, overwhelmingly. Lately here in Arizona, I've seen a lot of Chapter 13's filings. People file Chapter 13 for a couple reasons. One is their income is too high based upon their household size to qualify for a Chapter 7. Those income levels vary from state to state and sometimes from county to county. Or, if you come in and you're behind on your house payments, you need to get that caught up. then it's something where they can we can put you into a Chapter 13 and you'll have time to get it caught up. Chapter 13 is very long. It can be anywhere from 3 to 5 years. Most Chapter 13s are 5 years long. So a full 60 months, 5 years that you're going to be in this Chapter 13 case. And because of that, a lot of things happen during 5 years. You may need to get a different vehicle, your home. And so people wonder what's going to happen. Surprisingly to most people, you can get lending while you're in an active Chapter 13. I've had clients just this year in 2023 have gotten new mortgage loans while they're in an active Chapter 13 bankruptcy. Typically, the banks look at things like how long you've been in the Chapter 13. They're going to want to see that you're making your plan payments on time to the bankruptcy trustee. But also, you're typically going to have to get approval either from the court or from the trustee before you can go forward with it. You can't sell your house. You can't sell assets. You can't buy a new car. You can't incur new debts unless the court approves it. And in some situations, particularly the case if your plan has already been approved or confirmed, at least in Arizona, only the trustee has to sign off on it. So it is possible. That question, there's a lot of moving parts there, but I do tell people that if you're in a Chapter 13 and you got to get a new vehicle, or I recently had a client who they had to move because they got a new job. They were able to sell their house, buy a new one, and doing all of that while they're in a Chapter 13. So, all right, well, let's jump over to the questions that have been posted so far. Ray, you made it. Thank you. I'm glad you're able to make it tonight. So, all right, let's see here what we've got. Let's see what this one says. Eric says, for any motions where there isn't a template on your site, should we use Chat GBT to write it for us? Also, if we file for arbitration and the suit is currently stayed, what do we need to send to the plaintiff? Okay, let's talk about Chat GBT first. Artificial intelligence. I did a video a little while back about artificial intelligence and how it's going to impact the legal profession. Basically, it's going to put us all out of business. That's what it's going to do. It's powerful. And in the online courses, which I haven't talked about, the tutorial, the Consumer Warrior University, it's linked up at the top of the chat section there. This is where I have all my tutorials and forms and templates that you can use for all these types of things we talk about. We have started implementing the artificial intelligence into that, the Chat GBT, because it can be very helpful in drafting things, particularly like things like responses to motions for summary judgment and things where you have to put together a legal argument. I'm going to give you a little asterisk caveat here about what you need to be careful of with Chat GPT, because there's an attorney back east that found out the hard way that it's not always accurate. And actually, you need to check it for sure. So if you go into Chat GPT, and if you haven't done this, it's kind of fun to play around with. You can just go there and you can use it for free. You can put in there, write a legal brief on a motion to compel arbitration, citing New Jersey law or Arizona law, and you can put some different specific facts that you want it to do. And boom, it punches this thing out, and it's almost as good as anything any attorney's written. And it's likely because it's drawing from all these documents and things that other attorneys have written. And it'll even cite to various case law. And I've done this where I've used the same question, the same query that you put in there, and I've changed it. I'll say, okay, do the same legal brief, but use Arizona law. Then do it again, same brief using California law. And it'll cite to different citations. Well, this attorney, what they did is that they wrote a legal brief and then submitted it to the court. The problem was the court went and took the citations, the case citations, that they were relying upon for legal authority, and they ran them through what's called Westlaw or Lexis. Those are the big platforms that you can run cases through to see what they are. So the judge wanted to read the cases. It turns out that Chat GPT just made it up. The cases didn't exist. I saw this thing and I plugged those cases in and I was like, holy cow, they weren't real. It had just essentially, I don't know if it's a glitch in the system or what it is, but it just made up these various case citations, and they looked legitimate. I mean, it was the, John versus Doe, and I had the court, the what we call the pinpoint site, where it was showing the exact page number. And so, and it's not to say that it does that every single time, but what you need to do is you need to make sure that the case citations that it's submitting, because you have to submit legit stuff to the court. You can't just make stuff up and throw it in there. Is make sure it's a legitimate case that it's citing to. And the way that you can do that, you can go to Google Scholar. I think it's scholar.google.com, or you can just put in Google Scholar. And Google Scholar, it actually has a little button you can press on there to search under case law. And then I would recommend putting that case citation that Chat GBT put in there and running it through there to see if an actual case shows up. Because if a case doesn't actually show up, then you know it's not real. That's good. And Google Scholar is free, so you can plug that in there and at least make sure it's an actual reported opinion before you cite it to anything to the court. So, Eric, that was my long explanation on Chat GBT. It's a powerful tool. It's going to be super powerful and put consumer warriors like myself probably out of business unless we figure out how to adapt to it, which we will, of course. But you got to be careful with it. As to your second question, if you file for arbitration on a lawsuit that's currently stayed, what do we send to the plaintiff? So when you file for arbitration, whether it's through AAA, through the American Arbitration Association, or through JAMS, they're going to give you some documents and things you need to send to the other side. So once you submit that through their website, they'll send you emails and stuff of what actually needs to be sent. So, all right, let's see here. Travis Family Travel says, I live in Arizona. I filed a motion to set a trial date. With in-person required, the motion was denied. What to do next? I think we talked about this last week. There's probably nothing you can do. Unfortunately, that's not something you can appeal. That's something procedural that the court's going to have, the discretion to be able to decide. It stinks, but you're probably just going to have to do the trial via phone or Zoom or however they're doing it. The only thing I'd do is I'd make sure to talk to the clerk of the court. If you have exhibits that you want to look at and have presented at court, that you need to have them see what their procedures are, because they're going to want you to submit those usually several days in advance so that they can get them ready. You could file a motion to reconsider, unlikely to be granted. So, all right. Rio says, are funds held in an LLC bank account fully exempt from judgments? Do we have to show proof it's an active account? And if the funds are later moved from the bank account, can the creditor go after those funds? So if a creditor has a judgment against you, so the whole reason why they file lawsuits is because they want to get these judgments, because that gives them the power to garnish wages and then to garnish bank accounts. Now, they can only go after bank accounts if the name of the LLC is listed as a named defendant in the lawsuit. So if they get a judgment, so I work for Jackson White PC, professional corporation. If someone were to get a judgment against Jackson White PC, they could take that judgment and try to garnish the bank accounts of Jackson White. But they would not be able to garnish the personal accounts of John Skiba, because I'm not a named defendant. It also works the other way. If someone were to sue me and get a judgment against John Skiba, and I'm the only named defendant, they're not going to be able to go, garnish or levy the bank accounts of Jackson White, because they're not a named defendant. So they are fully exempt. However, it does get a little bit tricky if there are, let's say that you're the owner of the LLC. So your LLC owners are called members. If you are the only member, or you and your spouse are a member of this LLC, it is possible for the creditor to go and get what's called a charging order against the LLC. And what this is they go to the court and they say, hey, we have this judgment. We think that this LLC, it's only owned by Rio Jones here, and we think that they're hiding money in there. They can get a charging order, and the charging order against, if the creditor is successful, the charging order against the LLC, it does not allow them to just go in there and sweep the bank accounts. But what it does do is, if there's any distributions from the LLC to you personally, they can garnish those. So if you have this LLC and you're self-employed and you're paying yourself and you get a paycheck every 2 weeks, or if you do owner draws or something like that, then it's a situation where the charging order will allow them to sweep in and take those funds. So, let's see here. This one says, I have a car that is a total loss, and now they now want me to put full coverage on a total vehicle. I filed Chapter 13. I don't know why you would need full coverage on it. I guess I don't know if it's they. If the typically you don't have to change. You have to have insurance if you're going to be driving the vehicle, but there's nothing in the bankruptcy code that requires you to carry full coverage on it. So that may be an insurance thing, but particularly if you have an attorney, talk to your attorney on that, and they can help you with that for sure. When you are sued by a debt collector and you are on Social Security, disability, should you include proof of your Social Security income when you answer the lawsuit? I'm not currently in the situation, but curious. I always say when you respond to the lawsuit, when you're actually filing the answer, you don't want to. The mistake I see is that people put too much information. Filing an answer, it's not your time to tell your side of the story. It feels like it should be because the complaint, it feels like it's their side of the story. So you want to share your side of the story, but it's not. What they want to know in the complaint is, they want you to respond to the specific allegations in the complaint and be able to, so that the court knows whether there's like an actual dispute. Do you disagree or agree with what it is that they're alleging? It's not a time to put in settlement offers. It's not a time to put in your financial condition. If you're going to try to settle it, so you could file the answer, but then if you're going to submit a settlement offer later on down the road, then you could put that information in there. And then, yes, I would recommend if you're on Social Security, if that's like your sole source of income, I absolutely let them know, hey, that it's Social Security is the only income because it's exempt. They can't garnish it. They can't touch it. And so that will help give you some leverage to either get the thing thrown out or at least get some type of lower settlement on it. So let's see here. Let's do this. This is what happens if they have a warrant for your arrest. Can you actually go to jail and do time? Just curious. So this is a good question. I get this one quite a bit. Am I going to end up in jail if I don't pay my credit cards? The answer is no. There's no debtor's prisons. They can't take your, they can't take you to jail because you can't afford to pay your medical bills or whatever. Where people get in trouble and where you can end up going to jail is if you ignore the court, if you ignore a court order. And so where we typically see this is where the lawsuit gets filed and then there's a judgment that gets entered against you. And then they do what's called a judgment debtor's exam or post-judgment discovery, where the court orders you to appear so that they can take your testimony about assets that you have and things like that. In Arizona, that order to appear to the judgment debtor's exam, if you ignore it and you don't show up, the court can hold you in contempt. And then they can issue, and this is Arizona procedure, but I've seen it in other states, they can issue what's called a civil arrest warrant, which is, it's not where they're, banging on your door in the middle of the night, kicking the door down and dragging you to jail. It's not that. It is, though, if you get caught speeding on the freeway, there will be a warrant in the system for your arrest. They'll take you into custody. Absolutely, they'll do that. And they take you into custody, and then they take you down to the court, make you testify to what you were supposed to testify or bring the documents you're supposed to bring, and then they'll let you go. So if you have this order to appear, so what you're going to jail for is for contempt because you're ignoring the court's order, not because of the debt specifically. So the theme there is if the court issues an order telling you to be there, you need to show up. Get an attorney, even if you don't have an attorney, show up and make sure that you do what you can, even if you don't have all the information. So, all right, let's see here. This one says, debt lawsuit was filed 2 years ago. I answered, no contact with plaintiff ever. Plaintiff filed voluntary dismissal without prejudice last week. Statute of limitation passed almost a year ago. Docket says case closed. Any ideas? Yes, just be thankful because if the statute of limitations is passed, they dismiss, even though they dismiss without prejudice, they can't they can refile the suit, but if it's truly outside the statute of limitations, they're not going to be able to pursue it again. So and that's a danger. If they dismiss, that's them saying, and creditors, they never want to dismiss with prejudice unless it's part of an agreed upon settlement. So it doesn't surprise me that they dismiss it without prejudice, but if the statute has truly run, like you're saying, then I wouldn't worry about it. I wouldn't offer to pay it. I wouldn't do anything. I would just say that thing is in the rear view mirror here. So, all right. Christian says, I have mediation coming up. What should I expect from the other party's attorney? So mediation, which is different than arbitration that we talk a lot about here on the channel. Arbitration is kind of like an informal trial where literally they're putting on evidence and there's cross-examination and then the judge or the arbitrator issues a ruling. Mediation is where there's an independent mediator, an independent party who comes in and sees, can we broker a deal between the parties? You know, a creditor here says $8,000 owed. You're telling him to pound sand. And the mediator saying, look, instead of fighting this out in court and paying attorney's fees and all that, why don't we see if there's some type of middle ground here that can be reached? Usually how they do it with mediation, particularly with these kind of cases, they will put the parties in two different rooms and the mediator will just go back and forth. And they'll talk to the plaintiff's attorney and say, what do you think? You know, you want 8,000? They don't have 8,000. Would you take 6? And then they go talk to you and they say, hey, they want 8,000. And you're like, I don't have 8,000. Would you be willing to offer 2? And maybe get some additional background, you know, like, and this kind of comes up like we were talking about with the Social Security disability. You can say, look, here's 5 different reasons why I can't pay him. I lost my job. I'm on Social Security. I have another judgment. I'm already being garnished. You know, there's all these things. I don't have real estate. Those types of things can lead to a settlement. And then the mediator will kind of go back and forth. This is helpful in particularly cases where it's if you're not represented by an attorney, because not that the mediator is representing your interests, because they're not, but it's just nice to have kind of a buffer. And like I said, what should you expect from the other party's attorney? You're probably not going to even be dealing with them. You might be together at the very beginning just to get some instructions, and then they'll separate you guys and the mediator will deal with them directly. So Emmanuel said, if you had a default judgment against you, but you and the debt collector come to payment arrangements, does the judgment get removed? Yes. So once in Arizona specifically, if the judgment is paid, they have to file a document called a satisfaction of judgment, even if it's paid pursuant to a settlement agreement where you're paying less than the total amount owed. So they would be required to submit this satisfaction of judgment to the court, showing that it was paid. In other states, and it's something you want to bring up for sure. You know, if you're negotiating the settlement, that they're going to remove this. It doesn't remove it, at least in Arizona. It doesn't remove it from the docket. You know, the court will always have those records, but it will show that it was been paid. And if they've recorded it, like with your county recorder, they often will do that because it will then act as a lien against any real estate. You want to make sure that they enter a release or file that satisfaction so that if you go to buy a home or sell a home, it doesn't cause you problems down the road. So let's see here. Someone says, one of my credit card companies sent me a letter stating they wrote off my debt. Does this mean it will be sold to a collection agency? You know, the charge-off happens 180 days after the account goes into default. So if you stop making payments, roughly 6 months later, they'll charge it off, which is really kind of an internal tax classification for the creditor, where they're saying, hey, this is a loss. We're not going to be able to collect on it. It does not mean that they can't continue to try to collect on it. So it's possible a lot of creditors will sell their debt to junk debt buyers like LVMV Funding, Midland Portfolio, all those companies. That's when they do it. It doesn't mean necessarily that they will, though. Like American Express, they don't sell their debt to junk debt buyers, but they still charge it off at 6 months. So it may or may not, just depending on the creditor and the bank, you know, how it is that may determine if they're going to actually do anything with it. So Jennifer says, hello, I have an SBA loan, $266,000. Can I file for bankruptcy? I earned, I got to have some water. I earned $5,000 this year in my taxes. I have a mortgage and a car loan. So SBA loans do go away in bankruptcy, assuming that they're not secured. So part of it will depend on if it's like connected to like your home. If it's a secured debt, it's not going to go away completely. But if it's an unsecured debt, SBA loans go away completely in Chapter 7 bankruptcy. No payment required. It's just discharged. So you may want to meet with an attorney in your particular state and see exactly if it's something that you qualify for a Chapter 7. But yeah, I think that assuming that it's not a secured debt, it'll go away. A lot of people are surprised by that, just because the federal government does back a lot of the SBA loans, but they're not protected. They don't get special protections like student loans or other types of debts. They'll go away completely. So, Alex, a man down in Yuma, what's the usual time frame for a person to file a suit from the time of the last payment? Can personal loans be sold to a debt buyer? From the time of the last payment to filing a lawsuit, it varies. I've seen it where an account goes into a default, and personal loans anything can be sold. I've seen a fair amount. There's companies out there that do medical debt, and they will sell the medical debt. Anybody that deals with any type of large account receivables, it's a way for them to get some money, to monetize it and say, hey, we're not going to collect on this $100,000 in receivables, but we'll sell it to somebody for, whatever, $4,000, and then we'll let that be their problem. I've seen debt buyers. I rarely see from the time it gets sold until a lawsuit it being quicker than 1 year from the time it goes into default. I have seen it be as long as 5.5 years. Statute of limitations in Arizona is 6. So it just kind of depends on who the debt buyer is, how many times it changes hands, how successful they are in collections. Lawsuits are not the first thing they want to jump into. They're going to do, the annoying phone call kind of collections, letters, that kind of thing, before they're going to jump into any type of lawsuits. So it could be, within a year, it could be 4 or 5 years. It just kind of depends on the statute and everything else. So let's see right here. So, this one, Randman said, you'll know when the court is trying to get hold of you, I'm assuming correct, for a debtor's exam trial. Yeah, I mean, if you have an attorney, your attorney will be notified. If not, courts operate through the mail typically. So I was joking the other day that kind of a lost, I don't know what you call it, a lost habit. People don't check their mail. I don't know. I'm OCD on that. I check my mail every day, maybe because I do this for a living, and I see not checking your mail causes problems. If you are in litigation or if you're in bankruptcy, the bankruptcy court does everything through the mail. You need to check your physical mail every single day to see what's coming. So if you don't have an attorney, the court usually sends out those hearing dates via mail. The lawsuits start and you get served with the complaint and a summons, but you don't get, after that, they're not going to serve you each time. They're not going to have somebody come over and deliver it. They're not even going to send it certified. It's just going to come via first-class mail. So it's good to really, and with a lot of courts like in Arizona, you can check online and see really what's playing out. So you want to make sure that you're really paying attention to that. So, all right, let's see here. We'll do one more here. What's a good starting point, percentage-wise, to propose a settlement to original creditor, suit estate for arbitration? What's a realistic goal we should shoot for to settle? The amount is $10,000. If it's an original creditor lawsuit, original creditors are typically going to get more than like a junk debt buyer. And just because, one, they have all their documents, they have witnesses, it's not going to be hard for them to put that together. Two, that they're invested in it. They're going to say, hey, we lost all this money. A junk debt buyer who paid 2.5 cents on the dollar, they don't have as much invested in the whole process. So, if it's an original creditor, if Capital One or American Express is suing you, it's probably going to be somewhere in the 60 to 75% range. That's where it'll be settled at. I'd probably start about 40%. And I'd also be prepared, though, to provide information on why they should take less. What's the hardship? Like we talked about before with the Social Security. If your income is Social Security, if you don't own any real estate, you ought to let them know, I don't own any real estate. So those types of things, because you got to view it from their perspective. I always say sometimes my job is to help the other attorney sell this to their client, because if it's something where from the creditor's perspective, if it's going to be difficult for them to collect on it, if it's something where you're not working, your wages are exempt, there's no real estate that they can lien, or maybe you're self-employed, so it's going to be a lot harder to do any type of garnishment. Those are the types of things where usually they're going to say, okay, I'll take somewhat of a discount on this because it looks like it's going to be difficult to get squared away. So that's what I do there. All right. I think that's pretty good. We've got about a half hour into that. If there's any other questions, put them in the comments. Maybe I'll get to them next week when we do our chat then. Look up at the top. I think it's over here. Check out the Consumer Warrior University, all my tutorials, forums, anything like that. Appreciate you checking in. If you are in the state of Arizona and you want to be of help, check my number down there below. I'd be happy to see how we can help you out. And with that, we'll take it from there. I'll talk to you next week.